Good afternoon. My name is David Jones. I'm Vice Chairman of this subcommittee and I'll be chairing the meeting tonight. Now I've got a statement to read out concerning the operation of these online meetings. I'd like to remind everyone that this meeting is being streamed live on our website and is being recorded. Remote meetings are something new to us. Their unfamiliarity and the need to get used to the technical operation mean that they are unlikely to go as smoothly as meetings held in person. So I hope that everyone taking part or observing will bear with us. To help us, councillors have been given guidance on the conduct of remote meetings. I'd just like to emphasise a few of its points. Hopefully, the members of the subcommittee are taking part from a place where they will not be disturbed or distracted. When they are not actively participating in the meeting, I would ask members and officers to keep their audio and video turned off. Anyone wishing to speak should type H in the chat box and I will call them when it is their turn to speak. All questions and contributions must come through the chair, and please remember to turn on your video and audio when I call you to speak. Any councillor with an interest in any item should declare it and keep their audio and video off when it is being considered. They will not be included in any vote on the subject. When it comes to a decision on any of the recommendations or motions before us, I will assume that if no one says that they oppose them, everyone will be in agreement. If anyone says they are opposed, I'll ask for a formal vote to be conducted. If we lose the live stream on the website, I will adjourn the meeting for 10 minutes and hopefully the problem can be fixed. If it cannot, I will adjourn the meeting until a future date. Could I first of all have any apologies for absence?
Thank you, Chair. I'll just run through who's attending this evening. So you're here as Chair, obviously, and the two other councillors that we have with us are Councillor Davidson and Councillor Roberts. Councillor Lane hasn't joined the meeting, so it will just be the three of you this evening. In terms of officers, I'm here from Democratic Services. William Butcher is from Legal Services. He's the solicitor this evening. And Nigel Dermott and Daniel Winter are from Licensing. The other parties we have attending, from Essex Police, we have Gordon Ashford and Rachel Saville. Paul Brooks is attending in his role where he put in a representation as the Licensing Authority. David Hook is here representing the leaseholders as Mr. Webb, and he's also attending. Thank you, Chair.
Thank you. Could I have any declarations of interest? I'll assume the silence indicates that no one has any interest to declare. The first item that we have to consider is the minutes of the meeting held on the 25th of August 2020. Does anyone have any items to raise on that? Are they a true record of the meeting? Thank you. I shall take that.
Sorry, Chair. Sorry? Just quickly check something. I've just seen Councillor Rajesh has joined the meeting. I wasn't expecting her to be attending. Can I just check if you're subbing for Councillor Mullane?
No, I haven't. I have been sent this invite, but I don't know if I'm subbing for anyone.
No, I don't think. No, you'll just be observing this evening. It will just be Councillor Jones, Davidson and Roberts actually on the committee.
All right. I mean, if I don't need to be here, then I can leave the meeting.
Yeah, that's fine. Yeah.
Yeah? All right. Thank you so much.
Thank you. Bye.
Thank you. Okay. Right, to move on, the next item on the agenda is an application for review of a premises licence, the Bay Horse 189 Wilsham Street, Chelmsford, Essex, CM20LG. Could I first of all ask the ask for the person making the application to present their case.
Will be Dan Winter speaking first to introduce the report.
Thank you.
Yeah, thank you.
Good afternoon, members, colleagues and guests. The committee is requested to consider an application made by Essex Police for a summary review of the said premises licence under Section 53C of the Licensing Act 2003, and to have regard to the representations made during the consultation period that followed in the line with the promotion of the licensing objectives as detailed in the report. Members are advised that they have the following options when determining this application: to modify the conditions of the licence either permanently or for a period not exceeding 3 months, to exclude the licensable activity from the scope of the licence either permanently or for a period not exceeding 3 months, to remove the designated premises supervisor, to suspend the licence for up to 3 months, or to revoke the licence. An appeal against the final review decision made by may be made within 21 days of notification of the decision by the licensing committee, by the licensing officer, chief officer of police, or any other person making relevant representation. Any decision, any decision taken by members today does not take effect until the end of the 21st day following receipt of the decision made in respect of this matter. Therefore, under Section 53D of the Licensing Act 2003, members are also required to formally review the interim steps previously imposed and consider whether it is appropriate and proportionate that they remain in place, modified or withdrawn. This review must take place immediately following the determination of this application, which should consider any relevant representations that are made. In carrying out that review, members have all the options that were available at the interim hearing, and that decision will also apply until the end of the 21st day referred to above, A, or following any appeal made against that decision, or B, or at the end of any period determined as relevant by the licensing authority, which may not be longer than the period of time for which such interim steps could apply under A or B. Any decision taken by members in respect of the interim steps may also be appealed to the Magistrates' Court within 21 days of being notified, and in the case of an appeal in respect of an interim steps, the appeal must be heard by the court within 28 days commencing the day the appeal is lodged. The premises is a city centre venue located on Walsham Street, leading away from the main High Street and surrounded by commercial properties and residential properties within the vicinity of Hall Street and Orchard Street, and licensed by Chelmsford City Council under the Licensing Act 2003. A copy of the premises licence is attached as Appendix A. On the 12th of August 2020, Chelmsford City Council received an application from Essex Police for a summary review of the licence at the Bay Horse on the grounds of serious crime and disorder and the failure to promote all 4 of the licensing objectives, which was accompanied by the required certificate of a senior police officer. This application was initially supported and joined by a representation made on behalf of the licensing authority in their capacity as responsible authority. In response to that application on the 13th of August 2020, the Licensing Subcommittee considered the application and determined appropriate interim steps in order to promote the licensing objectives, in that the licence was suspended and the designated premises supervisor was removed pursuant to Section 53B of the Licensing Act 2003, pending the determination of this full review hearing. A copy of the interim decision notice is attached as Appendix B. The Licensing Authority has received no application to modify the interim steps imposed on the 13th of August 2020. This application was made by Essex Police for a summary review of the premises licence under Section 53A of the Licensing Act 2003. A copy of the application and the certificate signed by a senior officer of police is attached as Appendix C. The application has been properly made in accordance with the Licensing Act of 2003, and all procedures have been correctly followed. The public notice was properly displayed and copies of the application served on the premises licence holder through their legal representations and responsible authorities. The application was also advertised by Council's website. During the consultation period, the authority received representation from Environmental Protection Services on the grounds of prevention of public nuisance. I attached this as Appendix D to the report. On the 26th of August 2020, received notification of representation from Hook and Partners solicitors who act on behalf of Mr. Stephen Webb, Walsham Properties Limited, who currently hold the lease to the Bay Horse and who have subsequently formally registered a notification of interest in the premises licence under Section 178 of the Licensing Act 2003. This notification has the effect that the licence authority have an obligation to inform Mr Webb of any changes made to the premises licence. This representation was to inform that they will be producing supplementary and supporting documentation, including witness statements in support for their client's proposal that neither revocation nor suspension of the licence would remain necessary or proportionate. Under Section 18 of the Licensing Act 2003 hearings regulations, representation of supporting documentation may be produced either before the hearing or with consent of all parties at the hearing. I have attached a copy of this letter as Appendix E. For the purpose of clarity and from records held on behalf of the licensing authority, it is important to note that the premises licence is currently held by Spirit Pub Company Services Limited, part of Green King Group. At the time of the incidents referred to by Essex Police, the designated premises supervisor was Miss Francesca Webb, who gave notice to quit the licence on Monday, the 10th of August 2020, who was replaced by Mr Gary Mannion later that same day on an application. Excuse me, I'm going to read that again. Monday, the 10th of August 2020, and who was replaced by Mr Gary Mannion later that same day, an application to vary the DPS made on behalf of the premises licence holders. A further application to vary the DPS on the licence was made shortly following the interim steps that has the effect that Mr Webb is the current DPS. Although following the interim steps, the hearing of the DPS was removed, Mr Mannion at that time. During the course of the consultation, we received representation from Essex County Council as a responsible authority on the grounds of the protection of children from harm. Attached to this report is a copy of this representation as Appendix F. During the course of the consultation, we received representation from Chelmsford City Council as a responsible authority on the grounds of prevention of public nuisance and prevention of public safety. This is attached as Appendix G to the report. No representations have been received from any other responsible authority nor interested party. Since the police submitted their application for a summary review, they have submitted further evidence in support of this. This is also included as attached to as Appendix C. The premises licence authorities authorises the following licence activities, which are detailed in the report below. To conclude, the relevant sections of the Statement of Licensing Policies are brought to the attention of the members and others as follows. Where relevant representations are made, the Council will seek to make objective judgments as to whether conditions may need to be attached to various authorisations to secure promotion of the licensing objectives. This application has been correctly submitted. At the conclusion of this hearing, members are advised to consider the options previously recommended. And thank you, Chair, and everyone. That concludes my report.
Thank you, Mr. Winter. Just before we proceed, I did make a few small mistakes before Mr. Winter spoke. I should have confirmed that make sure that all parties understand the procedure to be followed at the hearing, and that the members of the committee have read on and reflected on the representations made. I'll take that as an affirmative. I also wanted to point out that only those who have submitted representations will be allowed to speak at the meeting. Anyone else can attend and observe, but are not allowed to speak. And now I should have asked, does anyone wish to withdraw their representation? I take that as no. I should also ask if there has been any request to adjourn the meeting. I'll also take that as no. Okay, to move on, I would now ask the applicant, who I believe. Thank you.
Good evening, Chair. I'm Gordon Ashford. I'm the Licensing Manager for Essex Police and represent the Chief Officer of Police, together with my colleague, Mrs. Rachel Saville. If it pleases, my intention is to give a very brief overview of the situation before handing over to my colleague who's got more detailed knowledge. I take it that's okay, Chair.
Yes, indeed.
Sorry, wait for you to swallow your tea. Okay. Serious incidents took place on the 9th of August, as already detailed in our submissions, and that was captured by residents and subsequently uploaded to Facebook, showing just quite how close to the premises there is residential property and obviously the concerns of the residents. Our submission sets out a number of incidents over recent months that ultimately led to the decision to ask for a summary review. One of the issues that's pertinent to this is that the operation and management of this premises lies at the issue of these repeated instances. As you've heard from your Democratic Services representative, the licence is actually held by Spirit Pub Company. That is a company that's, via various subsidiaries, is actually a daughter company you might consider of Green King. So Green King actually are the premises licence holder, and they are the landlords of the building. It's a condition of that lease, I understand, from Green King, that the premises licence must be held in the name of Green King rather than any operator, etc. It is usual for a premises that's got a tenant sitting in it to actually have the licence in their own name, normally, rather than in Green King's name, but not always the case. And this is what creates some of the problems. They have, Green King, the licence holder, have no day-to-day control of the premises whatsoever. In fact, they have no direct mechanism for ensuring the operation of the premises is in accordance with the Licensing Act and the objectives of the Licensing Act. They have no direct oversight. For some time, Spirit Pub Company, stroke Green King, have handed day-to-day operation of the premises to Emulsion Properties Limited, represented, I believe, today by Mr. Steve Webb and Mr. Hook as a legal advisor. And until very recently, that company itself has had no day-to-day involvement in that premises, but instead handed it to Mannion Group Limited under the direction of Mr. Gary Mannion. Even though the period whilst Mannion Group Limited operated the premises, the designated premises supervisor, which according to the guidance should be the person responsible for the day-to-day running of the premises, was indeed a Webb family member. However, they were quite clearly subservient to Mr. Mannion in that that person was sacked from their position on the Friday before this most recent incident took place, which resulted in that individual then relinquishing herself as the DPS on the Monday following the incident. So we've got a remote licensing holder who's absent, and unlike in a normal tenanted pub situation, they cannot physically control the management of the pub. And this ultimately has led to this sorry state of affairs. If the licence isn't revoked, the Emulsion Properties Limited is free to devolve again its responsibilities to another operator or itself to run the pub without Green King being able to have a significant influence on it. As you've heard, Mr. Hook represents not the licence holder, but the operator. And this again demonstrates the hands-off approach that's taken by Green King towards this particular premises. I would like to draw the committee's attention, for when it's in recess, to our submission at Appendix C, which sets out relevant case law. So in 4.6 of our submission, listed as Appendix C, in page 6 of our bundle, that our bundle has numbers to the top left of the pages. So at page 6, paragraph 4.6, 3 particular stated cases are set out, all of which demonstrate that it's relevant to take into account what has happened, what the likely impact is on the persons around the area and crime disorder, in preference to what might be the economic outlook for the premises if its licence is revoked. And I'd ask you to significantly read those, if I may, in recess. My colleague would explain further that we believe revocation is the most appropriate step, but should you decide that is not the way forward, then we'd ask the licence is suspended, that the hours of operation of the premises are reduced, and that you impose conditions as set out within our document 14 set out in Appendix C, and that's at page 42 of our document. Again, top left indicates the page number of our document. Those proposed conditions were circulated to Green King, and Mr Hook responded to us on Friday, saying out their agreement potentially to some of those conditions. Though, of course, we say revocation is the way forward. And before I hand over to my colleague, I just want to touch briefly on their submission, if I may. Mr Hook has set out condition 4, saying that it's never been a problem, the use of external promoters, and therefore that shouldn't be a condition that's imposed. However, effectively, Mr Gary Mannion and his firm were external promoters. Neither the licence holder nor their tenant had day-to-day operation of the premises, and this is what's caused a significant issue, hence why we believe if a revocation does not take place, condition 4 is appropriate. In condition 10, which is resisted, the explanation given is that they don't think they need 2 supervisors because they've done all right before. However, the previous instance and the incident on the night in question quite clearly show 2 door supervisors has been insignificant and doesn't prevent the issues. Not only that, in that submission, Mr Hook clearly states the users of the premises would continue to use the car park as an overflow. This is exactly what happened on the 9th of August and caused the serious disorder that took place. In condition 16, which is again is refuted, Mr Hook argues they shouldn't have to use polycarbonate glasses, etc. after 10 p.m. Yet these were used as weapons on the 9th of August. Quite clearly, lots of them were used as weapons. The condition wouldn't prevent restaurant diners sitting at a table with glasses, because quite clearly the condition we put forward excludes the use of the restaurant diners having to use polycarbonate. It merely seeks to make sure that weapons such as glasses can't be used by those that have got more intoxicated as the night goes through. And finally, the proposed condition 18 restricts entry only after 2300, and it's there to prevent those that are already intoxicated elsewhere in the town centre from using the pub as a later opening pub as a destination premises and attracting current issues again. I'm almost finished, Chair, before I hand over to my colleague. The only other thing I wanted to add was that when you consider what steps you intend to take, whether that is to revoke the licence, to suspend or impose conditions, etc., and change the hours, we'd ask you that when you consider your interim steps following that decision, that the interim steps should mirror your decision. So if you do decide to amend the conditions, the hours or suspension, then those interim steps that you consider should, I would say, reflect your decision. If I'm okay now, I'll hand over to my colleague, Mrs. Saville, to just give another overview, but with a bit more detail than I'm able to provide. Thank you, Chair.
Thank you.
Good afternoon, Chair.
Good afternoon.
Hopefully you've had an opportunity to read the full submission, so I'll just provide a brief overview of the reason for the application of summary review by Essex Police. Essex Police have significant concerns regarding how the Bay Horse Moleston Street is being run. A serious outbreak of disorder took place on the Sunday the 9th of August, where multiple persons began to fight using glass as weapons. This resulted in 4 people being taken to hospital for serious injuries. In essence, the Bay Horse staff and management lost control of the premises. Referring to Exhibit RS2, these recordings show the scale of the fight. In the footage, you can hear glasses smashing and people screaming. A male who sustained serious injuries can be witnessed being kicked whilst on the ground. Edited police body-worn video footage and statements provide the subcommittee with a sound and defensible rationale as to why it should revoke the licence. The footage can be viewed via Exhibit RS1. This incident was preceded by several other incidents which are listed on page 50, document 16, which include incidents of underage drinking. Essex Police have identified underage drinking at the premises from an incident on the 7th of August, where a 17-year-old male assaulted door staff after drinking at the Bay Halls. Exhibit RS4 shows a picture of the assault and a picture of the same person captured drinking inside the premises. Footage from police body-worn video suggests that the several people involved in these incidents are drinking whilst underage. This was further supported when a fingerprint recovered from a smashed glass in the car park of the Bay Halls has been identified as belonging to a 15-year-old male. The premises licence holders have given full control of the premises to a company known as Molsham Properties Limited, who have allowed Mannion Group Limited to sit on top and operate the venue how they wish, which has led to the continued disorder. The local authorities share the police concerns with representations made by Environmental Protection Services on the grounds of prevention of public nuisance and and another representation made by Public Health and Protection Services on the ground of public nuisance and prevention of public safety. A representation was also received by Essex County Council on the grounds of protection of children from harm. If the decision is made to go against our recommendations to revoke the licence, at the very least we request that the revised opening hours and conditions are implemented, which is set out in document 14. Essex Police also request that if the licence is not revoked, that the interim steps and suspension are put in place with immediate effect until the conditions on the licence are imposed. Thank you.
Thank you. Right. Could I now call on, I believe it's Mr. Piers Warne to make case for the licence holder.
Thank you, Chair. Hopefully you can hear me.
Yes, I can. Thank you.
Thank you. I do have some difficulties with this microphone sometimes, so let me know. Give me a wave or something if I fade in and out. Look, this submission is going to be fairly short because I think actually for you and your committee members, you're going to want to hear actually more from Mr. Hook and Mr. Webb, who operate the premises. But I want to just set out the position where we are from a Greene King point of view, so that you have full details of actually where we stand and why this isn't perhaps as unusual as Mr. Ashford made it sound. This is actually a fairly common way of dealing with licenses in a leased estate, but there are some differences here, which he was alluding to, but I just want to make sure we all fully understand how this works. The first thing that I'd say is this. I appeared before your colleagues at the interim steps hearing at very short notice. Greene King's position was we weren't going to oppose any suspension of the licence there. We felt it was appropriate and proportionate at that stage to take a step back so that everyone could have a look at what was happening, assess what had gone wrong, and then come back before you in a much better position to present rather than rushing through trying to open a premises, etc. And obviously you'll hear from Mr. Hook and Mr. Webb about that in due course. But Greene King do not condone any actions that undermine the licensing objectives. Greene King is a significant company with thousands of premises licenses, both managed and leased estate premises. So we know it from the managed side and we know it from the leased side. And where we can, we work very closely with officers from the council, police and committee members to try and assist where these things inevitably do happen sometimes. However, this case sits slightly outside of the norm within the Greene King estate. And let me just very briefly explain why, because it might help set out why there is this slight disconnect here. In 2011, Spirit Pub Group, as they were then, so before Greene King bought them, signed a lease with a forerunner to Molsham Properties, but a Stephen Webb vehicle. So essentially, Mr. Webb has operated this premises since 2011, so a significant period of time. It is not uncommon, and in fact, in all of Greene King's leased estate, Greene King holds the premises license, even though they then lease the premises to a tenant. That's across the full leased estate. This pub is slightly different in that this is a completely free of tie lease. We actually are we let the premises ourselves. We have a landlord, and our lease with the landlord is a very long lease, and under that long lease we are obliged to hold the premises license. So that's what Mr. Ashford was alluding to as this being slightly different. So we have to hold the premises license. But after that, actually, this is a very arm's length landlord and tenant relationship. We're not, in effect, a pubco here. We are the landlords who happen to hold the premises license. We were given permission by our landlords to sublet to Molsham Properties, and so that's where we are in terms of the position. Now, let me make this clear from a legal point of view, because I think it's very important to understand this. Section 16 of the Licensing Act deals with who can and who can't hold a premises license. There is no doubt at all, and there is case law to say that a landlord is perfectly entitled to hold a premises license and at that point take no part in the operation of running the premises. The key to the licensing law is the promotion of the 4 licensing objectives. At the end of the day, and your job partly, of course, in my submission, is to ascertain who operates the premises and take action accordingly. And it's very clear within the Licensing Act that this is very deliberate, and it was actually to add some flexibility to who could hold the license. So, for instance, there are offences in the Licensing Act where you can actually prosecute an individual who might be responsible for an act, the DPS, the premises licence holder. So it's a very flexible way of working, and I think that's very, very important here. And the leading case on this is from 2009. It's called Hall and Woodhouse. Lord Justice Richards and Mr. Justice Owen were dealing with just a case like this, but it dealt with a prosecution. So the local authority in that case in Poole had prosecuted the operator of the premises, but also the premises licence holder, who were Hall and Woodhouse Pubco. And what they had to say was this, and I'll just read these out very quickly because it gives you the context. Under section 16(1)(a), this is paragraph 24 of the determination by those judges I've just mentioned, an application for a premises license may be made by a person who carries on or proposes to carry on a business which involves the use of the premises for licensable activities to which the applicant relates. Carrying on such a business is self-evidently different from carrying on the licensable activities themselves, and the fact that a person's actual or proposed business involves the use of the premises for licensable activities does not mean that he necessarily carries on the licensable activities themselves. So I hope that's clear. This has been found in the High Court to be a perfectly rational relationship, where we are perfectly entitled to be arm's length in that relationship, which obviously can lead to some frustration if you don't know who you are dealing with. But in this case, there was a DPS at the premises. There was Molsham. We were not involved, and certainly the licensing authority had not contacted my client directly to express any concerns about the operation of the premises. If they had, obviously, we could have at least passed those on and made sure there was a direct line of communication. But we've been sort of kept at arm's length, if you like, during this process as well. That's not a criticism. I think it's an acceptance of actually how this all works. So from our point of view, I just have very few submissions then, because frankly, we haven't had much to do with the premises. Our submissions are these. Firstly, we've seen and considered all the paperwork, the reps and submissions by all parties. We, as I say, do not condone any actions that undermine the licensing objective. The second point is we've not been notified of any concerns with either Mr. Webb or his company. And as far as we're aware, there's no history of crime and disorder going back to 2011 until actually around the time of lockdown, it's been alleged, but certainly from July the 4th onwards when the premises opened. We weren't notified of that in advance. So that demonstrates actually, I think everyone was quite clear there was an arm's length relationship there. There is a long history of Mr. Webb and his company's operating this premises from 2011 that you'll need to take into account, as well as the last couple of months. I would also point out that Mr. Webb acted swiftly. So we got notice of the summary review application I think I got notice that the hearing was being held on 30 minutes notice, and I had the papers 4 minutes before the hearing. So I tried to read them as I ironed a shirt to come before this committee. But he acted very swiftly to remove Mr. Mannion, and he's not come back before you very quickly to try and reopen, which you would have been entitled to do. As you're aware, under interim steps, you can come back. I think that's, if you like, something to take into account in terms of the seriousness with which they've taken this. And I would say this finally, if you're minded to take the position that actually the management of the premises can be separated for the purposes of the incidents we're talking about here from a long history of management previously, bearing in mind what you're going to hear from Mr. Webb and his solicitor, Mr. Hook, we would suggest that the appropriate and proportionate action is to amend the outdated operating schedule on the premises license, which you can see at page 20 of your agenda. You'll see that some of those conditions are very out of date, very old fashioned, and replace them with the conditions that were amended from the proposal from the police. And I believe and understand, and obviously Mr. Hook will take you through this, that you obviously have the police proposals, but then you've also seen a document that sets out which ones are agreed and which ones aren't, and Mr. Ashford referred you to those anyway. So that effectively is where we are, sir, and I can't really add much more in terms of substance, so I will be quiet and let you hear from Mr. Hook and Mr. Webb directly.
Thank you. And could I then ask Mr. Hook, who is representing the leaseholder, and or Mr. Webb? Thank you.
And I'm the solicitor advocate representing the Webb family and Morsham Properties, as you've heard. You've now heard from those making the application, the police, and I know you and your colleagues will have taken very seriously the reading of all the papers that have been presented to you. I apologise that we weren't able to submit all of our papers earlier than we did, but we were running to catch up. I do have to say, though, I start from the position really leading on from what Mr. Warren has just said to you. These premises have been under the control and management of the Webb family through Morsham Properties since 2011. Morsham Properties, Mr. Webb entered into a management agreement, not a lease. You've got a copy of that with the papers that you've seen, because Mr. Webb Senior was taken very seriously ill late last year, to the point where for several months he was unable to walk. I'm glad to say he's in my office today, and I will make him available to answer any questions that anyone may have. But I think for the purpose of proceeding smoothly as possible with this hearing, it's best if I try and deal with all the issues. So there came a time late in 2019 where, for the reasons I've just explained, it was apposite to appoint someone else to manage the premises full time because Mr. Webb was no longer able to do so. Give you the background, Chair, members. His office was situated in the premises themselves, upstairs from the premises. That's how close he'd been involved in the running of the premises for the preceding 9 years. It is quite clear also that until June of this year, there had been no issues of note whatsoever at the premises, no criticisms, and you will know from reading the representation made on behalf of Morsham Properties that Mr. Webb himself has been a licensee. Names have changed since 2005, but he's been a licensee since 1982. That's 38 years, not 32, as I put in the representation, and I apologise for that. For 32 years, again, without blemish. Francesca, who is here this evening as well, was the DPS until she was removed, as you heard from your licensing officer, removed at her request because she felt that she had no ability to discharge the responsibilities of DPS when matters came to a head on the 8th and 9th of August. We are looking at a period of less than 2 months during which it would seem the management and the running of these premises went downhill rapidly. 2 or 3 problems that Francesca Webb encountered as DPS. Firstly, she was taken ill in July, and for health reasons related to the present pandemic, she was required to stay away from the premises for a period of 2 weeks. She then endeavoured to regain her contact and management and super oversight at the premises in that first week in August, as you've heard, and that eventually resulted in Mr. Mannion expelling her from the premises, almost certainly unlawfully, but then he employed his security staff to do that. And therefore, as soon as she was able, on the Monday morning, she contacted the licensing authority to explain the situation, and they immediately removed her from the license. And I understand for a period, Mr. Mannion was the DPS. Of course, your interim steps have removed Mr. Mannion, and quite properly so. But this family, you've read, I'm grateful, you've had an awful lot to read. I hope you've been able to read through my detailed representations, and I would ask you, when you decide what's going to happen, that you reread that to refresh your memory, because I do feel that the thrust of the police presentation this evening is unfortunate, because I don't think it gives a fair appraisal of the situation at all. It's much more a knee-jerk reaction to some terrible incidents that occurred in early August, with which we make no apologies at all, because it had nothing to do with us, but nonetheless, it was exceptional, it was unacceptable. And that, as Mr. Warren has already explained, is the reason why we didn't come back and ask you to change the interim steps. We wanted time to look into the matter fully, to find out exactly what had gone on. And although Mr. Warren advised you that the premises license holders had never been contacted, not at any stage were they contacted, that's bad enough. But Francesca Webb at no stage was contacted, and yet she had made contact. You've got a timeline from her with copies of documents, copies of texts. You can see when she contacted the authorities. So the authorities knew exactly who she was. This is in July of this year, 13th of July. She contacts the office to say she is concerned that the COVID precautions that she's been putting in place in consultation with your authority are not being adhered to. That's acknowledged and it's admitted. So you have a DPS who has an unblemished record. She's had a personal license since 2012. She's doing her very best. And for reasons best known to him, Mr. Gary Mannion, who had the management agreement, it's not a lease, by the way, you can see that from the paperwork that we've lodged. That's a first misunderstanding. It's not a lease, it's a management agreement. For some reason, he ran the premises from October through till March this year without complaint from anybody. And Francesca was working shifts each week so she could keep an eye on the place. And it was only after they reopened after lockdown that Mr. Mannion seems to have gone off the rails completely. And our efforts to enlist assistance fell on deaf ears. And to this day, the police have refused to discuss the matter with us, with me, with my clients, despite requests to do so. And we face an issue here where the license could be revoked, and we have been denied the opportunity of putting matters right, notwithstanding that we have this exemplary record over many years, 38 in the case of my client, Mr. Stephen Webb, of running premises without difficulty. Now, it was not clear to me, I have to say, until, and I'm grateful for Daniel Winter's very clear introduction to tonight's session, because it wasn't clear to me legally exactly who the designated premises supervisor was. I'm grateful to your licensing officers for assisting Francesca to remove herself from the license. Immediately matters came to a head. Mr. Mannion, it would seem, then did become the DPS. He holds a personal license from your licensing authority, and to my great astonishment, I checked last week, he's just been granted a SIA badge as well. And yet we know how he dealt with the running of these premises. Now, we have an issue in that, yes, if you looked at the web and you looked at Moulsham Properties, because they're one and the same, and you said these people have shown no responsibility ever in running these premises. The police were seeming to try and suggest that there was a complete disconnect. Now, that nothing could be further from the truth. It was only because Francesca tried to impose her will as designated premises supervisor and got pushed out suddenly and rudely that matters came to a head on the 8th and 9th. It was the 8th that she was barred from the premises. The first date she could get hold of your officers was the 10th. They were very helpful then. But in the meantime, this dreadful series of incidents occurred, which were truly appalling, totally beyond our control. So what we're saying is, and by the way, we accept the police evidence in terms of the facts of what occurred. I'm not instructed to question anything about that at all. And indeed, their take on the law is pretty well spot on. However, that doesn't mean that you have to or even should lean towards revocation in the case of these premises, because you take into account the whole history. Yes, there was dreadful incidents on the 8th and 9th, but they are exceptional. They're not the usual thing that goes on at these premises. They're not typical. They've never happened before that short period between June and the beginning of August, less than 2 months. So we're asking you to look at the track record of us running the premises and to allow us to run the premises again. There are a couple of ways that you could ensure that, if you're happy, if you would be prepared to allow the Webb family to resume conduct. One is, these are alternatives. We did suggest, and I sent a copy of the proposed condition, that whatever happened, there should be a condition that Mr. Mannion, who you've removed as DPS, should never be allowed, whether by himself, his company, or anybody else, to have any influence or control over these premises. And I have to tell you, sir, that as recently as last Friday, now bearing in mind, we actually shut the premises down, we repossessed them, we excluded Mr. Mannion from the premises before your emergency hearing, even before you'd served papers on Mr. Mannion, because actually they were served on him as we were closing the premises, putting him out and sealing the premises up. So those, as that's already been said, those are the steps we took as soon as we knew what the situation was. But as recently as this Friday, Mr. Mannion, in company with 2 or 3, well, to use the term loosely, gentlemen, endeavoured to re-enter the premises. Now, clearly that was resisted, and I have to say, although my clients have enjoyed no contact, no liaison, and no support from the licensing department at the police, the town centre police at Chelmsford have been fantastic. They have attended with my clients for a variety of purposes at the premises. First, to secure them on that Thursday in the morning. Secondly, the police want the CCTV to assist them with their inquiries. Mr. Mannion had endeavoured to sabotage that. We've managed to recover the recorder. We sent it away to the manufacturers because Mr. Mannion had tried to prevent anyone from reading the recordings. That, I am told, my clients just tell me, has been received today, so my client will be in touch with the town centre police again to provide them with the evidence they want. That evidence would seem to be quite shocking, I have to say. You will be aware that there has been, since the relief from some of the lockdown, there have been a lot of what are called rave parties, unlicensed entertainments, house parties, and incidents like that. The fact of the matter is, you speak to the serving police officers on the streets, that's all to do with the drugs industry. The drugs industry suffered like every other industry during lockdown. They're now trying to organise all these events so they can quickly sell what they've not sold before. And that would appear to be what happened on the 8th and 9th. But that CCTV will be in the hands of the police from tomorrow for them to pursue the best they can. And my clients will give any other assistance they can. Likewise, when Mr. Mannion endeavoured to push his way into the premises, because he definitely wanted to stop that evidence becoming available. Town Centre Police were fantastic. They were there, they were supportive. And sorry, I was just gesticulating to one of my clients where the toilets were, sir. I do apologise. So there we are. It would be a tragedy because the reason that this pub was originally the sublease, if you like, from Green King to my clients is in the name of a property company, because you may well know, sir, much better than me. I'm a Southend boy, not a Chelmsford boy. Well, that was a long time since I was a boy, of course. But you may well know that this premises fell into total disrepair, was locked up and sealed up. And my client, because he also has a building company, refurbed the premises, reopened them. They are normally lovely premises. I did provide some photos which relate to the period when we were operating the premises and the first few months when Mr. Mannion was operating the premises. There's this extraordinary change after lockdown, like it would almost be a different person was running it. I said there were two alternatives. One would certainly be, and I have drafted a condition which I know Daniel Winter has a copy of, but only very recently, which would exclude Mr. Mannion from having any control, influence, or anything to do with the premises at all. The other alternative that you and your colleagues may wish to consider is, because the Webb family have run the premises, these premises for 9 years without any trouble, and many other premises over many years without any trouble, you may wish unusually to attach a condition to this licence that the licence should be operated by the family themselves, by one of them. Now, I have to say, Mr. Stephen James Webb, the father, for reasons I've explained to you, is probably not a fit enough person to be the full-time person in charge of the premises. But I would ask you and your colleagues to consider this as a viable alternative to ensure that the premises go back to the way that they have been run for many, many years. Now, turning to, and with all due respect, the submission by the police today really takes or doesn't even appear to know how the premises have been run previously, nor who the Webbs were, what their history was, notwithstanding that we've provided those details. So there are many conditions suggested, Chair, as by the police. We have made comments on some of them. Mr. Ashford commented on our comments. Let me just go back over a couple that he raised. Condition 4, Chair, the one about outside promoters. Outside promoters have been used at these premises for 9 years without any trouble. Outside promoters means somebody wants to hold a record fair. It doesn't mean some rave freak who wants to run something dreadful, because it doesn't fit with the way we run the premises. So It's not been a problem previously. Also, there is no evidence whatsoever that at the time of these problems at the premises, they were being run or they were functions arranged by external promoters. So if external promoters have had nothing to do with the failures at these premises, it would seem inappropriate and unnecessary to attach a condition relating to that. Condition 5 is about the CCTV. I've spoken a little about that. We're having to reinstate the CCTV. We'll upgrade it in accordance with best practice and the requirements of the police. Condition 10, again, with all due respect, I think our comments have been utterly misinterpreted. When we're running the premises normally, Chair, we would say we've always run them with 2 doormen, and that's been more than adequate for 9 years. That's all that's necessary. You will be aware at the moment there are temporary provisions allowing some people to sit outside pubs, but so-called extension of pavement licences under emergency legislation. And we would accept that during any such operation, a 3rd doorman might be appropriate. But the real reason that the doorman failed, as will be shown from the CCTV in due course, is they weren't even trying Mr. Mannion's doorman. We now have evidence that they were told not to intervene. And as far as the police are concerned, that's the town centre police, they actually ran away, leaving the town centre to police to deal with issues. So condition 16, again, I'm not sure that Mr. Ashford understands quite how serious a move away from glass is as far as customers are concerned when you're trying to run a nice premises. We have in the past always volunteered a polycarbonate condition, as you've read there, when we've given a temporary event notice for any particular other function or extension. So, in other words, when it has been appropriate in the past, we've done it. We've tendered that. We've offered that. Again, condition 18 seems disproportionate. You have the remaining comments. I think the last one I want to settle on is condition 26, which is the last one, which deals with the use of door staff. Well, Mr. Mannion, who we now know is an SIA doorman himself, and his door staff, proved entirely unsuited to the task, to say the least. My client has many years of recruiting door staff on whom he can rely, and that's what he wants and needs the discretion and authority to continue to do. My clients are very distressed about what's happened to this pub that they had rebuilt from a shut-down ruin. They're very proud of the 9 years when they ran it. They would still be running it, but for the unfortunate illness of Mr. Webb last year, when he was bedbound for several months. He is now much better, but he is still, with all due respect to him, still rather frail. And I don't think the full-time running of the premises on his own is something that would be right to ask him to do. But he has the 2 family members who are more than willing, and as you know, we've put his son, Stephen Webb, forward to be the new DPS. We fully understand your decision to remove Mr. Mannion as DPS. It is something we would have asked for if you had not already done it. Now, looking forward, there is a technicality which has been raised by your officer, by the police, and even Mr. Ward, which is that whatever decision you make tonight, there's a 21-day delay on it taking effect because of the time to appeal. And that therefore the interim steps should continue during that period. Can I just say this? Just as we have not applied to vary those interim steps because they were taken in reaction to extraordinary circumstances. we would be prepared to go further and say this. If, for example, you decide not to revoke the licence and impose conditions along the lines that we've suggested, we're going to need 3 weeks to get these premises ready to reopen anyway. So we would not have any objection to the interim steps continuing for 21 days, because that's time we'd have to use to get ready to make the premises COVID safe again and to be ready to open. So that we're not in a situation where if you make one order, we're going to try and sneak in the back door and undo another order that you've made. That's how open and forthright we are, and that's how we would like you to consider us and the matter. Chair, if there are any matters with which I can assist you, or Mr. Webb or Francesca Webb can assist you, we stand ready to do so.
Thank you. I'd just like to go back to Mr. Warren and just ask him if he has any, if he wants to make any comments on the condition from Mr. Hook.
Chair, I presume you're talking about the condition that only the Webb family can use this license. We would be happy to accept a condition to say Mr. Mannion and any of his companies are not permitted to have any running of the premises in the future. We would not be willing to have a condition on the license that's saying only the Webb family can. That would suggest there are no other good operators in the country. And after all, Green King did find Mr. Webb. With tongue in cheek, I say they found Mr. Mannion. So no, we wouldn't accept only them operating our license, but we would certainly accept a condition that Mr. Mannion and his companies are to have no longer have any operational control or management of the premises under this license.
Thank you. Okay. Could I, at this stage now, ask if the police have any
Chair, to jump in. We haven't heard from Paul Brooks, who is one of the people in the presentation.
Beg your pardon, yes.
Ask him if he wants to add anything.
Yes, thank you. Could I ask Mr. Brooks to come forward? Thank you. Thank you for reminding me.
Thank you, Chair. No, at this stage, I don't really have anything to add to the representation that's at Appendix G. The only thing I suppose I would like to clarify is this question about why the DPS was not contacted. And I think it goes back to what Mr. Ashford said at the beginning, that it was quite clear to us that Mr. Mannion was in charge of the premises and in charge of the operation. And as we were dealing with him, there was no need for us to contact the DPS because the DPS was subservient to Mr. Mannion. And our representation is around the blatant disregard to any regulatory advice, and even especially on the nuisance and the noise nuisance, that disregard that actually, when being told to turn it down, he did do, and then half an hour later he turned it back up to the previous volume. So nothing more to add. The only thing I would like to highlight is my colleagues in Environmental Protection on their submission did say that if members are minded not to revoke the licence, that they would like to see a reduction in the opening times and also a condition about no amplified music to be permitted to be played in external areas. So I just draw your attention to that. Thank you, Chair.
Thank you. Could I just ask Mr. Bird, is Mr. Mould here?
No, he's not attending.
Okay, right, thank you. So in that case then, could I go back and ask the police representative if they have any questions?
Hi, Chair. I just wanted to clarify a few things. In regards to Francesca's contact to the licensing authority, this was regarding COVID guidance. So our review is being brought for the crime and disorder, not the non-adherence to the COVID guidance. I'd also like to point out that we contacted Green King today to discuss the meeting and was told that they would get back to us, which they hadn't. So communication has been tried. Also, regarding the community policing team, we're obviously in discussions with them a lot and work very closely with them. I'd like to also point out, in regards to the point made about no incidents before July, was it? We've actually had quite a few incidents, which I've just looked back on, and a letter was sent out by the local authority regarding an incident last year on New Year's Eve. This was in regards to an event taking place which is unlicensed. So there has been incidents prior to July. What I would also want you to note is just the seriousness of this incident that took place. And I don't know if you've had time to view the body-worn video from officers and the Facebook links. If you haven't, I would suggest that you do. And I do feel that the responsibility shouldn't just sit with one person, who is Gary Mannion, who they are obviously blaming. But that's all from me. Thank you.
Thank you. Does Mr. Hook have anything to add in response to that, or indeed Mr.
Yes,
Hawke?
thank you, Chair. Yes, I most definitely do. I'm sorry. I can understand why everybody's trying to absolve themselves of not having contacted the DPS nor the premises licence holder. But the fact that Mr. Mannion was at the premises does not absolve them of that. The premises licence holder have their own stance, they have their own solicitor here. But the DPS showed, as soon as she was aware there were serious matters wrong, she dealt with them. And Molsham, as soon as they were aware that Gary Mannion was out of control, closed the premises down, excluded him from them. Now, maybe it's entirely logical if the police, if that information had actually been passed to the DPS a week before, when there were some less serious incidents, premises could have been closed a week before that and Mr. Mannion excluded. But no, they were allowed to go on. And the point being that everybody knew who the DPS was. She was in the premises normally 2 or 3 days a week. She had been in touch with the authorities. There was no conceivable excuse for not contacting her. And I'm sorry, that just doesn't wash. And because the police, in their own letter of objection to Stephen Webb, the young Stephen Webb, being put forward as a DPS, state that the DPS is the most important position at the premises, and yet no effort to contact the DPS at all. Nothing that I'm saying should be taken to try and reduce what happened at the premises. That was absolutely unforgettable, unforgivable, and it's something with which the Webbs have never previously been associated. But just because one person goes rogue does not mean a family history of nearly 40 years running premises like this. And the attitude that's displayed is suddenly we're coming up with something that happened New Year last year, but it wasn't a licensed event. I'm sorry, that questions bona fides. It's just unfortunate and shows, I'm sorry, a level of detachment that has contributed to the problems at these premises that the town centre police have had to deal with. So I do feel quite strongly about that, Chair, as you probably just realised. But it's not good enough to say they spoke to Mr. Mannion, because we have since discovered at the premises that Mr. Mannion had concealed all paperwork that he'd received. He'd not passed on anything. Nothing had been sent to us. We had nothing from environmental health, nothing about noise nuisance, and yet everybody knew who we were and what we could do, and that we'd never done this previously. So I'm sorry, that just doesn't wash. But there you are, Chair. I'm sorry. I think that needs to be borne in mind by you and your colleagues. I know you'll look at the whole thing in the round, and I thank you already for the colossal amount of time that you and your colleagues must have spent reading all the paperwork. And I would just ask you to remind yourselves particularly of the matters in the representations on behalf of Moultrie Properties. Thank you, Chair.
Thank you. Could I ask members of the committee if they have anything that they want to ask either the applicant or the licensee or the Moultrie Properties?
I haven't got any, Chair.
Thank you, Councillor Roberts. In that case, then I've just noticed that there is. Oh, thank you.
I haven't got anything either.
Thank you. Just noticed that there is a raised hand for Mr. Warren. Is that something from before?
No, Chair. You invited me to make some comments, and Mr. Hook, who I can see why he wanted to jump in. Obviously, it was burning in his breast to say what he said. So
that's fine.
I thought I'd wait and come back if that suits you, Chair.
That's fine. Carry on.
These are effectively my summing up comments, if I may. The first thing to point out, obviously, is the paragraph in the guidance that I think is key here for making a determination on a matter such as this, and that's paragraph 9.43, which for your legal advisor is page 75 of the current iteration of the guidance. And it says this: an authority's determination should be evidence-based, justified as being appropriate for the promotion of the licensing objectives, and proportionate to what it is intended to achieve. And if we take those factors in mind, then the previous history does become very relevant prior to Mr. Mannion and his egregious, I think it's a fair word to use, running of the premises. I don't want to. He's not here, and it's very easy to suggest, one is throwing someone under the bus for the crimes of everyone else. But it's also very fair to say that what the evidence points to here is a willful desire on his point to exclude anyone else from what he was doing. The problem with that, of course, is that it does leave everyone on the outside, and this is where collegiate working, and frankly, I was very pleased to hear from Mr. Ashford, who I've worked with over the years on many matters for various clients, and Rachel as well. Rachel acknowledged that we have a good working relationship with Green King. In terms of whether someone contacted Green King today, I can't comment on that, but what I can say is I spoke to Mr. Ashford today, so there has been contact between the police and myself on behalf of Green King today to talk through where we were. Mr. Brooks said he went straight to Mr. Mannion when they had issues, so that, if you like, gives you a evidential basis for saying that premises license holders aren't the first and only recourse for any issues that come up. It does depend on the nature of the premises, and this, as I say, sits within a leased premises, and it's not just Green King. There are various other pub companies who hold premises licenses on behalf of tenants, and there's various reasons for doing it that don't need to worry you today. But what I'd say is this. If you're looking at what's appropriate and proportionate, when we discussed the evidence you've had, the conditions that have been proposed, I think, are the proportionate response as amended by Mr. Hook on behalf of his client. I think there is no evidence to suggest a reduction in hours is appropriate in these circumstances, given the long history prior of this license having those hours. Without concern, no one has pointed to you today to a history going back past this summer of incidents at all, let alone noise or nuisance that would cause you to have to reduce those hours. And the New Year's Eve incident that isn't in the papers, candidly, I'm not disputing that whether it happened or not, it's not in the papers, but that's still effectively under Mr. Mannion's watch. So that doesn't change anything you've heard today. Green King will always work with police, licensing authorities and committee members as and when we can, but there are these differences between the way premises are and the way they're run that must be taken into account. And I think it's very important here to consider that if one were to reduce the hours or were to impose a condition that said only Mr. Webb and his family can have control of this premises license, we would be getting ourselves into a very funny positions on the evidence presented to you. What we can definitely say is Mr. Mannion should have no more influence over this license or any ability to operate this premises. And that pretty much is all I say at this stage. On an evidential basis, I would put forward that the changes to conditions as amended would appear to be appropriate and proportionate in and of themselves, given the unique circumstances we all face ourselves under today. Thank you.
Thank you. I noticed that Mr. Ashford has his hand up. Could I call Mr. Ashford?
Chair, for me, it was just to clarify for your purposes and for Mr. Warren's purposes. Yes, myself and Mr. Warren did have a conversation today. My colleague made mention of a non-contact. I think that may have just been a misconstruction of an email exchange I had with my colleague earlier. So, yes, me and Mr. Warren did speak today. Thank you, Chair.
Thank you. So could I clarify, have all parties, well, rather, are all parties satisfied that they have had the opportunity to make their case and present any points and to ask any questions that they have needed to do?
I believe so, Chair. Thank you.
Thank you. So in that case, we will have to move on to deliberate this in private session. But this is a rather unusual situation because the next item is the application for the DPS, and as such, we will be moving into private session anyway. And so I have some wording here. I move that pursuant to Regulation 14(2) of the Licensing Act 2003 hearings, Regulations 2005, the public, including the press, be excluded from the hearing during consideration of Agenda Item 5 on the grounds that the public interest in so doing outweighs the public interest in the hearing, in that the documentation and matters to be discussed may involve the disclosure of personal information. Thank you.
Chair, I'll just quickly jump in. Just in case anyone who is watching on YouTube, what happens now is the committee will go off and deliberate and they'll make their decision. That then gets emailed around to the relevant parties and that'll be made available afterwards. What's happening now is a different application is being considered and that one is being done fully in private. So the YouTube stream will be turned off very shortly. Thank you.
Thank you, Mr. Berg.